Hello and welcome to the Money and Banking Law Podcast with Joe Silvia, brought to you by Duane Morris, an international law firm with roughly 30 offices and 1,000 lawyers all over the world. I'm your host, Joe Silvia. I'm a former Federal Reserve lawyer who represents banks, fintechs, and financial services clients on M&A, payments, and regulatory matters at Duane Morris. I'm also a core member of our banking, fintech, and digital assets and blockchain practices. Now, while we can't provide legal, financial, investment, or tax advice on the podcast, our goal for the Money and Banking Law Podcast is to inform and educate our clients and friends on both the fundamental concepts and structure of the banking ecosystem, as well as critical developments in the law and regulation of money and banking. Thanks for joining us today. As always, if you have any questions from any of our podcast episodes, please reach out to me at jsylvia@duanemorris.com.
On this episode, we're talking about the proposed rule to implement the Genius Act Customer Identification Program requirements. So earlier this summer, the Treasury Department's Financial Crimes Enforcement Network, which is FinCEN, the OCC, the Federal Reserve, FDIC, and the National Credit Union Administration, the NCUA, issued a joint proposed rule that implements the Genius Act's requirement that permitted payment stablecoin issuers maintain an effective customer identification program. I'm going to refer to permitted payment stablecoin issuers as PPSIs, PPSIs, and a customer identification program as a CIP. So, as an overview of this proposed rule, we generally look at what they are proposing as very similar for what is already in place for the requirements related to a CIP at a traditional financial institution such as a bank or a credit union. So, as required by the Genius Act, this proposed rule proposes a CIP obligation for PPSIs and would require a PPSI to establish and maintain a written CIP that's appropriate for the PPSI's size, business, complexity, and so forth. This would be part of the PPSI's anti-money laundering and countering the financing of terrorism program. This is now referred to as AML-CFT. First thing that the proposed rule would require is that the CIP include risk-based procedures to verify the identity of each customer to the extent reasonable and practical. So identity verification procedures. These procedures have to be based on the PPSI's own internal assessment of the relevant risks in order to enable the PPSI to, quote-unquote, form a reasonable belief that it knows the identity of each customer. This is the same requirement that banks, credit unions, and other traditional financial institutions have. So very clearly following along what's already expected for what I'll call similarly situated institutions. The information that a customer is going to be basically obligated to provide are the basics: name, date of birth, if it's an individual, date of formation, if it's an entity we're talking about, and then address and some kind of identification number, whether it's a social security number, a TIN, otherwise. The rule requires that the CIP, the written customer identification program, contain procedures to verify the identity of each new customer within a reasonable period of time after the customer's account is opened. The proposed rule would enable verification procedures to include verification through documentary or non-documentary methods. Furthermore, based on the PPSI's own risk assessment for new accounts that are opened by entities, the proposed rule requires that the CIP program include procedures for that PPSI to obtain information about the individuals that have authority or control over the account, over the entity, in order to verify that customer entity's identity. Lack of verification. The proposed rule would require that the PPSI CIP include procedures for when the PPSI cannot form a reasonable belief that it knows the identity of the customer. The procedures need to describe when they should not open an account, the terms under which a customer can use an account while they attempt to verify the identity, and then when a PPSI should close an account after the identity verification fails, and finally when a SAR or a suspicious activity report should be filed in accordance with applicable law and regulation. There's also requirements around records, comparisons with government lists, customer notice, and then relying on other financial institutions. So the proposed rule would require procedures for maintaining records of all information that they require and obtain through their CIP. The rule would require the CIP to include reasonable procedures for determining when a customer appears on any kind of terrorist list issued by a federal agency, or some kind of list is designated by Treasury, so on. So a lot of information here. The reliance on another financial institution is also helpful. It allows a PPSI to include procedures that specify when they can rely on another financial institution's performance with respect to a PPSI customer that has opened or is opening an account. So it allows some information sharing. It allows similar to what we have now with traditional banks and credit unions. So there's specific exemptions that are talked about, but that's really exemptions by rule or order from FinCEN or the banking agencies. So at this point, we're just in the proposed rule stage. Comments are to be submitted directly to FinCEN. And like I said, we see here another example of the establishment under the Genius Act of proposed rules and regulations related to PPSIs, but focused on what is already out there as a requirement for banks, credit unions, other traditional financial institutions under FinCEN's regulations. So that's it for today. If you have any questions about this or any other episode, please feel free to email me, jsylvia@dwaynemorris.com. You can email any of your other favorite Dwayne Morris lawyers. Please be sure to like and subscribe to the podcast wherever you do get your podcasts. Follow on LinkedIn. Follow us on Instagram. We've got an Instagram page for the Money and Banking Law podcast. And watch out for new episodes coming soon. And we've got a couple of other webinars and other things happening soon on Genius Act related issues. So lots going on in the digital asset world, lots going on with respect to the Genius Act rulemakings. Stay tuned, and please like and subscribe. Thanks, and have a great day.